Thank you, everyone. Please be seated. We are here this afternoon for the submission of two cases, and the first one is a state of Kahn and Hodges versus City of Clermont, Fayette County Conservation Board, and Fayette County, as well as the state of Iowa. Looks like the parties are ready. It's my understanding, of course, Mr. Hixson will cover his base. Who is going to go first for the other side? No, but I heard there's going to be Ian, is it Youngward or Jongewaard? Jongewaard, okay. I would have said Youngward, but I will pronounce it, I figure you know. And then Zachary Clausen. So you two can just decide who goes first and also division of your time. I'll leave that up to you. Thank you. Mr. Hixson, you may begin.
May it please the court, counsel. Justices of the Iowa Supreme Court, I'm Russ Hixson. I represent the plaintiffs, the estate of Sharon Kahn and Vicky Hodges in this case. As you know, they went over a low-head dam. And when they went over this invisible low-head Clermont dam, they basically got stuck in the invisible hydraulics of that dam. Hydraulics that the state and the defendants were well aware of before this day. Dangerous hydraulics that the state knew would trap an individual in that dam. And that's exactly what happened on this day. These two ladies, mother and daughter, were trapped in this dam, and as the water took them down to the bottom and the hydraulics brought them back into the concrete wall and then up again and down, and it just recirculates, and they struggled and basically just struggled until they drowned to death in what the defendants knew and called before this date a drowning machine. I know that the parties have briefed this very well. The court really knows all the issues. I'd like to focus on the facts because I think the facts in this case and the misfeasance that we allege informs on what the law should be. So in this case, we patterned our petition after publications by the DNR before this date. Publications that basically said a drowning machine is a term used to describe the dangerous situation that's created when water flows over these low-head dams. The recirculating current, known as hydraulics, can take an object, an individual person, to the bottom, and the current brings them back up to the dam. This recirculation can hold even an object, even a boat, indefinitely, and become impossible even for an expert swimmer to get out of. This was a drowning machine. This is a killing machine.
The administrative code indicates that when one of these water trail projects are established, the parties are supposed to enter into an agreement governing responsibility for the project, management of the project. Do we have that in the record? And what does the record reflect on who has responsibility for what?
We don't have that in the record. We were not able to get it. We are not obviously allowed to do any discovery in the case because the case was dismissed on motions to dismiss. We alleged, of course, that all of the individuals installed the warning signs for the dam. We know that many of them had DNR warning labels on them. We know the city had obtained funds.
Let's assume that, I know you're alleging kind of joint responsibility for the project as a whole, but could it matter to the outcome depending on who owns the dam, who has responsibility for signage, et cetera, in that agreement? In other words, is there a fact issue here on that question?
Matter, but it's, as we indicated in our brief, many of these are fact issues. I mean, the court is required to assume all well-pled facts as true and all reasonable inferences, and we didn't know exactly who placed which signs. We know the city of Clermont received funds, undertook the duty to warn of the actual dam itself. We know that initially there was a cable along the dam, before the dam, just like I saw when I came down the interstate and saw the one over the Des Moines River Lowhead Dam with warning signs. And the city had received funds, had put those up, they had a cable, they had the dam warning, and that had come down. And the city had done nothing to replace it.
I take your point with respect to the city, but with regard to the state, why isn't their role somewhat analogous to that of the state of McFarland? In other words, in McFarland, there was another local entity that owned the dredge, maintained the dredge, put up the buoys, and the state's role was basically, well, okay, they in effect own Storm Lake, and why isn't that the role of the state here analogous? Because sort of under the public duty doctrine, you're responsible for your own work, but you're not responsible for how you exercise kind of a government regulatory responsibility with regard to somebody else's work.
We think, and we attempt to show that McFarland is much different. First of all, we point out that McFarland was a close decision. It was a 4-3 decision with Justices Hecht, Appel, and Wiggins saying, no, the public duty doctrine does not apply here. We would hold the defendant liable.
Been on the 3 side, and the majority is the law.
Understand, but the case here is different. In McFarland, there was no allegation that the state had placed the buoys, right? Or that the state was responsible at all once they gave control. And the court said, with control goes liability, right? In this case, we allege the state placed warning signs. They might disagree, but at this point in the litigation, the court has to assume that that's true. The state placed the warning signs. I think this is different also, Your Honor, because in McFarland, the court clearly noted that the danger that was at issue was created after the state had handed over control. In this case, the danger was there when the state knew it was going to designate this as a state water trail.
Question about Chapter 461C. So the state is arguing here that its liability under Chapter 669 extends only to that which a private person could have. And in 461C, it says that private parties are not liable for permitting people on lands basically for recreational opportunities. And so the state's argument, and so there's a liability based on premises and liability based on warnings. If the state's right about that, if the state's argument is correct that a private party couldn't be held responsible for those things, how can the state be held liable here when 669 says that we can only extend liability to what a private party holds?
And I think Your Honor specifically noted the difference. I mean, there is case law where the Supreme Court has said that that section is couched in terms of premises liability. And in the course of Sally versus Stewart, the court noted that, look, it doesn't deal with active negligence. And that's why I wanted to focus on the misfeasance, is that if there is active negligence, then that doesn't apply. One thing
If I may, to warn is set out, though, in 461C. What negligence is at issue here that for the state that doesn't go to failure to properly warn?
response would be twofold, Your Honor. First of all, I think the negligence is the state included a drowning machine in a water trail that it promoted to the public. It created a situation where it says this is safe. It cleared land for parking lots. Our people used those very parking lots. It constructed those. It created signs and warnings for people that would use the state designated water trail. So I know the defendants would focus just on the dam. Our focus is you can't intentionally place a drowning machine in a state-designated water trail and then not have a duty to warn the public that they could be killed if they go over that drowning machine. Now, one thing that I noted in looking at the very chapter you're talking about, in looking at the defendant's arguments, is the fact that the state then goes on in 461C to define what a holder of property is. And it's not in their brief, and I apologize, I missed it, but the definition clearly says a holder means possessor in fee interest, tenant, lessee. Holder shall not mean the state of Iowa, its political subdivisions, or any political body or agency, departments, boards, or commissions thereof. The legislature was keenly aware of the issue, and they said, we're not going to include the state of Iowa. And they specifically said land includes land that is not open to the general public. By basically saying, hey, you can bootstrap in sovereign immunity, don't you go directly against the legislature's specific definition of what a holder of property would be. So we submit that they can't claim no liability under this section when the legislature specifically, as opposed to the general, and we always read the specific to control over the general in statutory construction. Our argument is you can't allow them to bootstrap in sovereign immunity when the legislature says this section does not apply to you. Did I answer your question, Your Honor? So we see the actions in this case very specific. The facts are, if you look at misfeasance, the state and the defendants cleared property. They created a water trail knowing that there was a drowning machine. They then invited people to that drowning machine. They undertook the duty to warn by placing warnings. Now we allege, as the court must assume, those warnings were not placed.
Actually, how far up the river were the first warning signs, and were they still within the city limits of Clermont?
I can't answer your question on whether or not they were within the city limits of Clermont. I do not believe that they were. The best we can tell, based on the warning signs, is the first one comes into play after the last exit, meaning when they could have gotten out. The first warning comes, and it's by a sign. And I think, if my recollection is, it said 2,000 feet to dam. The problem is, and my people would have floated right by that sign. It was about this high, right on the bank, and the grass was that high too. We have pictures the day after, you can't see the sign. The next signs that come up that are mandated by the state-adopted warning manual were down the river, and they were on the banks, but yet trees and brush were growing over them. You couldn't see them. We have pictures of them. We have pictures of the brush piles and the places where they went in and cut tree branches this big to get rid of the trees that were growing over those warning signs. If you cover existing warning signs, isn't it the same as not having any warning at all? And they knew they were required to have warnings. Getting back to your question about control, the state never gave up control over designation of that state water trail. At any time, the state could have said, this is not being adequately warned. We're going to take it off the state designation of a water trail.
Regulatory control. Having the ability to regulate something really isn't enough under the public duty doctrine.
But control is under McFarland. They're the ones that designated it as a state water trail, knowing it had a drowning hazard. So are we going to say they have that power, but if they undertake the duty to warn and the public's at issue?
The state could have shut down the dredge too. I mean, the state is kind of all powerful in Iowa. But the real question is it something the state, if the state put up the signs, that might be a different issue. But if the state had no role in the warnings, the dam wasn't the property of the state, the Portage Trail wasn't the property of the state, the fact that they just designated it a water trail, that strikes me as you're in public duty territory.
But we allege the state put up signs, which the court has to assume to be true. And so, and we allege the state specifically made a DNR water trail crew to help maintain the water trails. So as far as we know, until we get into the facts of the case, the state had an ongoing obligation to help take care of these water trails. As the county said in their brief, this was a partnership with the state. The state didn't just hand it over like they did in McFarland. Even the county recommends they were in partnership with the state in creating and maintaining these water trails. I agree. If this were a case on motion for summary judgment and we had the facts, and the facts are as indicated by Your Honor, then yes, it may be a motion for summary judgment based on the public duty doctrine. But this is a motion to dismiss before we even get to discovery and are able to delineate who has the obligations and how are they separated between the parties. We believe this is more like the cases of Breeze and Fulps and Estate of Farrell, where the court says, once you undertake a duty to warn of a danger that you help create, then you have an obligation. Breeze specifically talked about the Summer case with the golf course and said, when you develop, design, and undertake warnings, you have an obligation to complete those. I see my time's up. Thank you.
May it please the court, counsel. My name is Jongewaard, here on behalf of the state today. Your Honors, this case squarely falls in within this court's decision in McFarland, where this court emphasized that liability follows control. And here, the state had none. The plaintiffs don't allege that the state owned, operated, or maintained the dam. Instead, their theory hinges on the state's role in providing funding to local entities for purposes of managing the water trail and the dam. But providing financial support does not equate to assuming legal responsibility. The allegations amount to a claim that the state failed to ensure these local entities complied with the safety regulations it had set, precisely the type of claim that the public duty doctrine precludes.
Doctrine be avoided if the state had put in warning signs upriver from the dam, as alleged.
I would argue that it wouldn't. In McFarland, you had the state there who had sufficient control. It had control over other buoys that.
It didn't install the buoys along the dredge pipe that was submerged, did it?
Not specifically for the dredge pipe. But here, the plaintiff's petition alleges that the defendants at a whole had some duty in placing, or had some role in placing the warning signs. However, if you look at the petition as a whole, you'll see that the state's duty in allegations 24, 25, 52, 53, 54, 55, they all talk about the state's duty as one that sets regulations and criteria for placement and maintenance of these signs, and talks about how the state's role in this is to provide funds. And that conclusion is supported by the Administrative Code, Chapter 30, which talks about the state's role in providing funds under the Water Trails Program and under the Low Head Dam Program, where as a part of those programs, these local entities that have applied for the funds were responsible for ensuring that the dam was modified in a safe manner. And it specifically recognizes that warning signage of dams is part of these programs.
57, prior to 6/8/20, defendant State of Iowa, defendant Fayette County, defendant and/or defendant City of Clermont placed dam hazard warning signage upstream from the Clermont Dam. So they've alleged that your client was involved in doing the signage, which seems to me takes it out of McFarland maybe.
They allege that they were involved in some capacity, but as I mentioned before, if you look at these other allegations within the petition, it gives color to what the state's role was in the placement of these signs. And that role was that they provided funds to local entities that were responsible for them ultimately.
Both. I mean, you sort of pled in the alternative, which I think you're entitled to do if you have a good faith basis. They've said State was a regulator, state was a promoter, state was a funder, but state also was responsible for some of the actual, work that went into at least designing the warnings and implementing the warnings for the dam.
Your Honor, I would also like to point out that these decisions by the state would likely fall under discretionary function immunity. Specifically point the court's attention to Shelton v. State, a 2001 case that this court considered, where the defendant or the plaintiff there was suing because he had been hiking on state-owned trails, and he was suing the state for negligently maintaining those trails. In that case, the court found that the substances used in forming the trails, the placement or omission of warning signs, trail maintenance, were all matters for park professionals that were covered under the discretionary immunity doctrine.
It seems to me the argument is that the state already decided to put up warning signs. Did the state decide that it was not going to need warning signs anymore? It seems that the sort of choice was made earlier, and the state was just negligent in making sure that those signs could then be seen.
Well, I think that's the case here is directly on point with what the public duty doctrine is meant to preclude, which is that the state has a duty to enforce compliance by third parties with its safety regulations. And that's exactly the case that we have here. You have
Shelton to sort of mean that the state could choose whether it needed to put up warning signs or not, but once it actually decided, then the warning signs sort of needed to stay up, or they were negligent if they couldn't be seen. Do you read Shelton differently?
Yes, Your Honor. I think that these are all decisions that involve some sort of policy-based judgments, which that's also the case here. You have in the Chapter 30 of the Administrative Code, all of these different judgments that the state considers when making its criteria. They involve decisions, or they involve considering aesthetics of the park, financial resources.
So I understand, are you suggesting that the state could have discretion whether to put a warning sign up, but once it chose to put a warning sign up, it could have discretion to let that become blocked by grass or trees?
Under how these programs operate, and so it does have discretion where it's going to allocate its resources in maintaining these water trails.
That sounds like a summary judgment argument to me. I mean, if they've alleged that your client put up the signs and then allowed the bushes to become grown in front of them, and they weren't visible, 4 of the 5 weren't visible, doesn't that get you past the motion to dismiss?
Your Honor, again, I would argue that what they are alleging here is that the state had a role in this, but then when you look at the petition as a whole, that their role was clearly confined to funding.
If the state had actually went along and pulled the signs, kind of like an outward saying, we don't think it's necessary anymore, but to let them get dilapidated or have vegetation grow around it, isn't that completely different?
Your Honor, I'm not sure if I understand the point you're making.
And once you put those signs up, a duty to maintain, or if you don't think it's necessary anymore, wouldn't that be more appropriately evidenced by pulling the signs instead of just letting them go? I'm just saying I think that would be a better argument for you than the way the facts are in this case.
Your Honor. And I see that we are halfway up. Yeah.
That it is not protected by Iowa Code Chapter 461C2, given the definition of holder that excludes the state?
I would not concede that, Your Honor. And 461 contemplates our argument as it pertains to private individuals is that private individuals would not be liable here where they're opening their land for public use and recreation.
Argument raised in the district court.
The overarching argument was raised, specifically citing to that provision of the code was not raised, but
Its argument in the district court, it was a private person couldn't be held liable because only the state holds waters in public trust and no one else does. I didn't see any reference to this 461C kind of incorporation argument.
you're correct, Your Honor. There was no explicit reference to that. But I would point you to the case of Ames 2034 versus City of Ames, where the Court of Appeals cited JBS Swift versus Ochoa. In that decision by this court, they recognize that that's additional ammunition for the same overall argument, which is not a new argument advanced on appeal. Yes, I want to be respectful of my fellow counsel's time, so I see the rest of my time to him. Thank you.
May it please the court, counsel. The Iowa legislature has made a policy determination that municipalities in this state are immune from claims arising out of recreational activities that occur on public property. Before diving into the issue of recreational immunity, I want to point out something specific as to the city in this case. If you look at the district court order ruling on the city's motion, it was granted for the reasons stated in the city's brief in support of the motion for judgment on the pleadings. One of the primary arguments raised in that brief was recreational immunity. Because the plaintiffs failed to meaningfully address that in their opening brief, we urge that that issue is waived on appeal and that the judgment of the district court.
That order to say that, didn't the judge, I mean, I think the order was written in a way that maybe is subject to more than one form of interpretation. But she said, let me see here. Yes, it was a she. Yeah, I've got it right here. She said that for the reasons outlined in the written arguments of defendant, the board, Conservation Board, and defendant so-and-so, this court finds a dismissal of counts 9 and 10 is appropriate due to the applicability of the public blah, blah. For the reasons stated in the defendant's city brief in support of its motion, the court finds that it's properly granted for the same reasons. Do they mean same reasons of the brief, or do they mean they're granting it for the same reasons as they did for the Board of Conservation? I don't think it's clear.
The order could have been better written. We interpret that to say, for the reasons stated in this defendant's city's brief, it is granted for those same reasons.
Former trial judge, I think the way she wrote it, I might be guilty of saying the same thing. I wouldn't be proud of it, but granted for the same reasons. I'm granting it for the same reasons I just granted something else.
This court doesn't find that the issue is waived. We urge that the city is still entitled to recreational immunity under the plain language of the facts in the petition. What the petition indicates.
Dam.
Your Honor, the city has denied the dam in the answer, but for purposes of this appeal, assuming the allegations as true, yes, we're deemed to have owned the dam for purposes of this appeal. In terms
Allege.
that the city owns the dam. In terms of recreational immunity, the petition admits that the decedents were river tubing, and I quote, that river tubing is a recreational activity wherein an individual floats on an inner tube and allows a river's current to carry the rider downstream. This is exactly the type of situation for which the legislature granted broad immunities to cities to promote recreation and limit liability.
Isn't there some question about what you sort of sign up for when you go tubing? I mean, there's a risk that there might be sharp rocks at the bottom of the river, or there might be trees in the river, or there might be fishing line that you can get caught up on. But the fact that you might go over a dam and drown, I mean, isn't that a little different?
The risk in this case is death due to drowning. By its very nature, drowning is an expected risk of river tubing down a river.
Machine involved.
Even if the drowning itself is not enough, at all relevant times, the Turkey River overtopped the Clermont Dam. And so encountering
Normal and expected risks inherent in the recreational activity. And then whether, the plaintiffs knew or should have known that the recreational activity created a substantial risk of injuries or damages. That sounds like quintessential fact issue stuff in this situation. I mean, I tend to agree with Justice McDermott. It's one thing if they had hit a rock or something, but going over a dam.
Your Honor, our position is that at all relevant times, this river water trail overtopped the Clermont Dam. The recreational activity is tubing down the Turkey River Trail, and the dam was always present.
There you say, well, this recreational activity has this risk, and therefore it's a normal and expected risk associated with that activity. I mean, that's kind of circular, right?
Stronger argument if you had big old signs all over the place warning people, but then we're back to that argument as well.
Petition concedes that at least one of the signs were visible leading up to the dam. I believe that the court can determine as a matter of law that the decedents knew or should have known of the danger of the approaching dam.
The defendants concede that one warning sign was not enough, so I don't think you can rely too much on that petition, can you? Don't you need to read the whole petition?
You do, Your Honor, but one thing I want to point out, based on the other arguments so far, is that if you look in detail in the petition and the signage requirements, which come from Justice McDonald's questioning, is the state and the county are the ones who are alleged to be the partner in this river trail project. As it relates to the city itself, the only allegation of the city is nonfeasance for ownership of the dam, for failure to upgrade the dam. I see that I'm over time here. We'd urge that.
Around longer if we need to.
That last point. So, and I need to reread the petition, obviously, but are you saying that if you read the petition as a whole, the city of Clermont is not indicated to be a partner kind of in establishing, maintaining, operating the river trail?
I believe there is a paragraph, I can't point it to you off the top of my head, but it says that the state and county were involved in developing the Turkey River Water Trail. The city's role is as the alleged owner of the dam itself. For those reasons and those outlined in our brief, we would urge that you affirm the judgment of the district court as to the city. Thank you.
Mr. Hixson.
I want to first address the sign issue. As we allege in starting at paragraph 49, as part of the dual water trail low head dam programs, defendant state of Iowa developed standards for low head dam warning signage. 50, at all relevant times, state designated water trails, including the Turkey River Water Trail, were required by defendant state of Iowa to have low head dam warning signage installed and maintained consistent with the standards developed by the defendant state of Iowa. I know they argue that this was a discretionary function, but that discretion had already been exercised. They decided to place warning signs. In fact, they decided exactly how warning signs needed to be placed, where they needed to be placed, what kind. Their manual is even specific of saying how big your lettering has to be based on how far it is away for people to see it. You're talking about tubers floating down, looking up on a river. And so these standards are very important. The fact is they adopted those standards. They mandated that they be complied with before opening the Turkey River Water Trail up as a state designated water trail.
To that last question of the county, is the city part under the ordinance, is the city part of that responsibility, or is that a state and county partnership?
The way we understand, Your Honor, and the way we pled it, is that the Turkey River Water Trail was a water trail between the state and the county. But then they then gave funds to the city because the city owned the dam. So the city had the obligation and undertook the obligation to place warnings at the dam, to put warnings across the dam. Some of the warning signs, the ones that were grown over and you couldn't see, were placed on city property. There's a city park right there, and it was placed on the city's property, so I assume the city placed those. The portage that was mandated to be available and properly marked was totally grown over. you couldn't see. So even if somebody was aware of the danger,
Also on city property.
the portage was on city property, the city had undertaken obligations to warn of where that portage was. Even if our people knew you have to get out, there was no way for them to know where. Where do we have to go? Which direction do we have to move? For example, the city is required, they're mandated under their, the money that they received to put warnings on each side of their dam. One side doesn't have a warning at all. If somebody is coming down on that side, floating down on that side, there's no warning, but it's mandated that it be there. And so the city is obligated for that. We may get into it, Your Honors, and they may say, hey, this was kind of a joint thing. The state and the county, we're going to kind of do upstream, but we've made an intentional decision to include your dam. And so we're going to give you money. You're going to warn of the dam. You're going to put the warnings on your property. You're going to be responsible for the portage. That we'll know a little bit more after we get into discovery and find out exactly how it was delineated. But they were clearly received money, and they clearly undertook a duty to warn. It's no different than the voluntary undertaking doctrine that we talk about in our brief, that if you have voluntarily undertaken a duty, especially a duty to warn for third parties, to protect third parties, and you don't do that, then you're obligated. Well, this wasn't just a voluntary undertaking that was gratuitous. They received money to do it.
Recreational immunity argument and whether or not we can decide as a matter of law, kind of going over a dam in the state of Iowa on some of these rivers is normal and expected risk.
As we argued, Your Honor, it is a factual issue. Now, I don't know that this court is willing to say that a low-head dam is, as a matter of law, something that people know about. We cited cases right on point with low-head dams where the court specifically said, these are dangerous hydraulics. You can't see them. In fact, you can't see this dam upstream at all. How is this known and obvious? And more importantly, if it's a 5-foot high dam, that's how big the concrete wall was, and the water takes up part of that, it may not look dangerous at all, but courts have said, the Volpe court specifically said, the dangers of these hydraulics that will basically take you and pound you against the wall until you've drowned, they're not known to anybody. And in this case, you have to show not only that it was a normal risk of tubing. Well, that means every parent that takes their kid out knows that there is a substantial risk. It's not just a risk. It has to be substantial and that you know you could die. That was not the case here. Thank you.
The case of Estate of Kahn and Hodges is hereby submitted. And we'll just pause for a moment while the next attorneys get ready for State versus Skullerk.